make a case building. During the case building, the student may consult with the instructor. The instructor, we give them per team one instructor. It can be a lecturer itself, and also it can be a legal practitioner as an instructor. And then, for example, from one of the course, criminal law, we divide the moot court become three steps. The first step from the reading for the indictment letter, and then the second steps is the process when we have to give the evidence to the court, and then the third step is the verdict reading. The rules that we need per team, we can see from the slides. We have to provide team with 3% as a panel of judges. One become chairman of the panel, and then 2% become the member of judges. And then the second rules that are really needed by the teams is the legal counsel. It can be vary from 1, 2, or 3 students as a legal counsel. And the third, as a public prosecutor. Also, it can be vary from 1 to 3% as a public prosecutor. Defendant also, at least there is one defendant that have to attend the trial, but it will differ in the pandemic era, because the Supreme Court have a new regulation regarding the trial in the pandemic era. And also we need the rules a student become a registrar or swearing officer, only one person. And then also witness are charged. Witness are the charge. Witness are charged is witness by the defendant, by the public prosecutor, and the witness are the charge is witness from the side of defendant. Also, we need the expert witness from both prosecutor and then also from the side of defendant. We also usually give the student a chance to provide the case with a verbal witness or crown witness. It's optional, of course. And then one court officer who helps the presentation, or who bring the plaintiff or defendants to the courtroom. That's the rules from the criminal court. And then the legal documents needed in the criminal law court is one, police investigation report. We always encourage students to develop the case from the police investigation report. And then also the indictment letter, exception, intermediate verdict, proof of letter, list of evidence, plaidoyer, replic or duplicate, and the verdict, along with the judge's consideration. That's the legal documents that have to be provided by the students during the moot court session, and they have to give it to the lecturer, who become the judge who always give them marks when they role as a legal professional during the moot court. The second part is the private law. From the private law is quite similar with the criminal law system. We divide it become three steps. The first step from the lawsuit reading. The second step started with giving the evidence to the courtroom, and the third steps started with the verdict from the will be ended with the verdict from the judges. The rules that we need for private law, moot court, is first rules is panel of judges. It always consists 3%, one chairman of the panel, two member of judges. And then the second rules needed is legal counsel. It can be vary from 1 to 3. Also the public prosecutor, it can be vary 1 to 3 or 2, at least 1, yeah. And then plaintiff, defendant, register, swearing officers, witness, plaintiff, witness by defendant, also the court officers. Legal documents needed for private law is from mediation minutas, lawsuit letter, answers, replik duplik, letter of evidence, list of evidence, parties conclusion, and also the verdict made by the judges. And this is the one of the moot court simulation that we recorded from the 22nd National Moot Court Competition in Central Java. I think we can start to watch it now to give you a perspective about what we do in Indonesia. Okay, sorry. Is the video working? Hello? I can hear from Unila.
No,
Yeah? It's
no.
Video stop.
it's stopped?
Yeah.
Oh, I'm sorry.
No.
I have to resume it. Yeah.
Now it's stopped. Now it's stopped. This video is with voice or without voice? I mean, with audio
This
or
this
without
video is
audio,
with voice.
Iqbal? With
Yeah, with voice.
With voice. Okay.
But I don't know.
Then perhaps uh, but we cannot hear uh,
You
the
cannot hear.
video.
You hear.
No, nothing. But perhaps to save time, perhaps you can
Okay.
tell us and describe what's the video about.
Okay. I will stop sharing. Okay. As you see from the video, in the moot court, we have at least 15 to 17 people for the national moot court competition. And every team always consists of a legal drafter and also the people who will role as judges and all the participants in the court. And then as you see from the slide and the video that I have, I've tried to present here in my presentation. All students always at least have 2 or 3 times to become different party. They can become a witness, they can become expert witness, they can become the defendant, they can change the roles during the moot court session. And that's the moot court before the pandemic. But now, currently, we have new Supreme Court rules that govern the different procedure of how we do the how the procedure of the trial. As your information, Supreme Court regulation number 3 and 4 of year 2020 made a change for the procedure uh, during the trial process. For example, from Article 2 of Supreme Court Regulation number 4 of 2020, the legal counsel and defendant may not attend directly in the courtroom. So we can use the video recorded by the person in charge in the different room, and then they can not they can attend not directly in the courtroom. And then the second change that the Supreme Court made is the defendant who was being detained attend the trial by using the video conference facilities from the detention house. So from the past, before the pandemic era, the defendant always have to attend the trial in the courtroom. But now, after the Supreme Court Regulation number 4 of 2020, they can attend the trial not by giving a direct attend, but they can using the facilities from the detention house. And the fourth new rules that set up by the Supreme Court is the evidence can be presented in the digital platform. Not only hard evidence, they can examine it, and then but during the pandemic era, the hard evidence can be presented in digital platform that can be submitted to the registrar. And then the fourth change that being made by the Supreme Court is also regarding the legal documents. The legal documents can be submitted through email that provided by the court. So all parties not always bring the paper with them and then give it directly to the judges, but now they can submit it through email. And a lot of change, the similar changes regulated by the Supreme Court number 3 of 2020 that regulates about the private procedure during the pandemic era. And to setting up the digital moot court, I think we have to adjust the moot court rules by enacting the same or similar regulation with the Supreme Court Regulation number 3 and 4 of 2020. So then during the moot court course, students, not all students, because the student, the member of the team consists of 13 to 17 students. They not they can attend the moot court in the different places. So, for example, the next moot court that Airlangga will enact in 2021, only 3 judges and 1 prosecutor, also 2 legal counsel that will attend the moot court. But the others, the other member of the team, can attend the trial by using the video conference. So I think it will be changed from now on, since we have this kind of condition of pandemic. I think that's how we will adjust the moot court course with the recent condition and then with the recent Supreme Court regulation. So we hope that students will have the same experience, even though they cannot attend in the same room as the usual moot court that we always do before. I think that's all my presentation, Ms. Nilam. Thank you for your attention. Good afternoon.
Thank you, Pak Iqbal. Turn off your microphone and turn off your camera.
Excuse me, sorry, ma'am. Your voice is not clear.
Bapak Ibu sekalian,
Ms. Nilam, your voice is not clear. Ms. Nilam, you have a connection problem.
Sorry, Miss Nilam, you have bad connection, I think.
Is it still clear?
Now it's clear.
Is it clear now?
Clear. Yes.
I'm really sorry because today in Surabaya particularly, we have a very heavy rain, almost like thunderstorm, so that the connections is very bad. And
yeah, similar here. It seems,
yeah. Felisiano. Yes. Without further ado, I would like to invite Dr. Sascha, Sascha Hardt from Maastricht University to give a presentation on moot court in Maastricht University. Thank you, Dr. Sascha.
Thank you very much, Bu Nilam. Good afternoon and good morning, everyone. I think that these technical difficulties. Is everybody seeing my?
Yes, we can see. We can see.
Okay, because I hear my own echo in a weird voice. Anyway, the technical difficulties that we're having this morning, online, maybe not fully the present working on it. Nevertheless, I would like to present some point of note to you this morning. Sorry, the audio is disturbing me. I will switch off my speakers. I only have 10 minutes, and since the connection is breaking away time and again, I will limit myself to 3 relatively short points, and I hope to be done in 10 to 12 minutes. So first of all, I would like to speak a little bit about the meaning of moot courts in modern higher legal education. The purpose that moot courts fulfill, they're more than just a game, of course, and the methods that can be used. Then second, I'm going to briefly talk about moot courts in terms of physical distancing and the opportunities that digital mooting also holds. So we have heard how moot courts are normally done at UNER by Iqbal, and we will hear much more on the practical possibilities and the creative ways in which moot courts have been carried out online by our 2 wonderful guest speakers today. So I will keep this short. And then lastly, I will actually invite you to discuss some of the practical challenges and problems that I see in setting up moot court competitions or digital moot courts in Indonesia. So first, I think when thinking about the meaning or the role that moot courts can play and should play in higher legal education, we should start reasoning from the end, from the graduate that we want to see leaving university in the 21st century. That graduate is a slightly different product from what was needed on the labor market some 20, 30, 40 years ago. So a 21st century law graduate is expected to have, of course, a good knowledge of the law. But on top of that, that graduate is expected to come with a very large skill set. So that person should be able to solve legal cases in various domains, should be very good at written and oral argumentation and public speaking, and the skills that are generally needed in all legal professions, regardless whether it's in the private sector or public sector, whether they end up at university and teach, or whether they end up in courtrooms, etc. Also, graduates are expected to be versatile, be able to adapt to various positions in the labor market, and be intellectually independent. So essentially, we need lawyers that are able to very much think for themselves and approach legal problems independently and act professionally. Moot courts are one of the methods that we can apply in legal teaching to attain these goals, to create this type of graduates, because as is the tenor, of course, of the LEAP program and of everything we do in our efforts to modernize legal education and make it more student-centered. Mooting is one of these interactive methods that really try to involve students more than as mere listeners in legal education. So mooting, I think, should be understood as a student-centered teaching method, much more than a simulation and much more than just a game or a fun event. Because moot courts are active, the acquisition of knowledge works differently and very often better than by listening to a frontally delivered lecture. We've all experienced this many times as lecturers or as students. As soon as you become active and as soon as you are interested, take a role in such a case simulation, the knowledge basically comes in much by itself as you do your research. Much in the same way, the acquisition of skills through the practice that you get in mooting runs more smoothly than in more artificial ways of teaching skills. And since skills is such an important component of modern higher legal education, moot courts are quite an ideal and actually indispensable tool in legal teaching. Most importantly, perhaps, moot courts are one of the few situations in the legal curriculum where students leave the meta level. Very often when we are confronted or when we confront our students with legal problems, we expect them to solve these problems from a sort of overarching point of view, or from the position of the judge, if you want. In moot courts, where students are assigned the positions of one of the dispute parties, that is different. They leave the meta level and they really have to place themselves in the position that they will have later in their professional lives as lawyers. That is quite unique about mooting, and it is one of the things that happen very rarely at other instances in the legal curriculum. So therefore also I believe that moot courts are quite indispensable. Now, digital mooting. Of course, we have all been thrown into the cold water by the corona pandemic. We had, for example, planned to implement both an intracurricular, a new form of intracurricular mooting in the curriculum of UNER within this LEAP program. We have also planned to start up a new Indonesian moot court competition. Both of them we are still planning to do, but it seems that we have to do this in a different form. And let me start any thinking about digital moot courts by disclaiming that, in my opinion, digital moot courts can only partly substitute for the physical experience, because moot courts, and especially moot court competitions, be they national or international, are more than just what happens in the virtual courtroom. They are also meeting your peers, traveling to a different location, behaving in court and next to court like a professional. All of this can only be partly made up for by what we do digitally. However, on the other hand, digital moot courts hold opportunities of their own. And this is especially true in Indonesia and other very large countries where traveling is not always easy and certainly not always cheap and not accessible for everyone. Digital moot courts offer the possibility of having a moot court experience of sorts with very low access barriers. So addressing especially our dissemination partners, for example, we can invite in such moot court events, be they national or international, people from places where it is normally more difficult to take part in such events. There is no need to travel anymore. So digital moot courts are a much more egalitarian type of event, and I think that should be welcomed and should be used as an opportunity to integrate them more, even more, in the legal curricula in all universities, not just the few very big and prestigious universities. Also, the opportunities of digital mootings allow us to integrate mooting in legal curricula on a much more regular and normal basis. So to make them a fixed component of any legal curriculum. And I would really encourage everybody in here who is busy developing the legal curricula to consider this possibility, to integrate small moot court settings, not just in as separate courses or even separate parts of the curriculum, as we heard already by Iqbal, which is of course a wonderful facility, but also in your everyday work as legal teachers. Incorporate them as small parts of your everyday teaching activities. Teach a task, teach a topic, not by giving a lecture from time to time, but by organizing as a moot court. That is the opportunity, especially in these times of digital teaching, that we see these days. Of course, digital moot courts have to be organized slightly differently. We have to think of the technical infrastructure. It is of the essence, and I think this is an important part of the discussion that we should be having, that all participating students and staff do dispose of the necessary technical infrastructure, have access to the internet, have a good connection, that we choose platforms which facilitate this. We should also adapt our rules and procedures to digital moot courts. The LEAP project we have, and probably in many other similar projects around the world and in the moot court competitions we hear about later, rules and procedures have to be adapted to the digital environment. And we have to overcome access barriers, for example, by facilitating access for students who otherwise cannot afford or are not able to take part, by giving them access to faculty facilities, having them compete in special moot court rooms, which are outfitted with internet access, etc. One piece of advice that I would like to dispense here is that in the digital settings, it might be useful to let students act as parties to dispute, not necessarily as judges. To limit the number of roles that students are in, and to have the judges play. We need moot courts for, especially in this day and age, is that we see digital moot courts as one opportunity to help something we're all facing right now, probably that distance fatigue, overcome this, in my opinion, and to make digital teaching a little more attractive and interesting and engaging once more. Action, access, and costs to really facilitate using the opportunities that digital mooting offers, namely to create access for others. Yes, thank you.
Sascha, I think your voice is not really clear.
Also, I would like to invite the discussion on coaching and assessment.
Oh, Sascha?
Yes.
The last part of your presentation, your voice was really not clear.
Okay. Where should I start from? I will have my video first and share my screen again.
Yeah, probably that will make it better. Yeah.
Ma, belakang tuh.
Unfortunately, I cannot hear you.
Perhaps the last.
Ini aku nyampe sampai tumpah di belakang sana.
Sorry. Can the co-host help me to turn off the microphone of one of the speakers?
Okay, I just heard that my voice was clearer when I was not sharing the screen. So I tried to round off. I had only one slide left,
Yeah.
without sharing the screen.
Yeah, that's perfect.
I hope that as many of you as possible can hear me without the video and without sharing the screen. There is one thing that I would like to draw our attention to as people who, for a large part, I think, organize moot courts, and also as students who participate in moot courts. Moot courts usually simulate real courts, and normally they are somehow modeled after the one or the other specific real courts. So there will be a moot court that deals with criminal matters, and it's modeled after a specific criminal court system. Or there's the ELMC, which simulates proceedings in the European Court of Justice, for example. But shouldn't we also be, next to simulating actual courts, shouldn't we also be trying to teach how courts should work? And if so, how can we organize this? How can we incorporate this in a moot court setting? I think especially in Indonesia, where the court system is still in many respects, for example, the use of case law, the publication of case law, and by that also the use of case law in teaching, is still nascent and still in the process of, well, basically of construction, of building. Moot courts can possibly also play an important role here. And I would especially like to invite discussion on that topic, because I think it is one of the most important topics in the context of moot courts in Indonesia. For the technical ideas of how to organize moot courts digitally and how to face the challenges that we are also faced with this afternoon due to the rainy season, apparently, I'm very, very curious to hear more details from our two guest speakers. Thank you very, very much for your attention, and I hope that some of my presentation was delivered audibly.
Yes, thank you, Sascha, for your presentation. Well, yeah, I believe that today I don't know what happened, although we are separated like 1,000 miles, one in Indonesia and one in the Netherlands. But believe it or not, the internet here and the Netherlands, I don't know what happened, but yeah, it's not really as good as the previous meeting or the usual meeting that we already that we had previously. Without further ado, because we have very limited time, I would like to invite our next speaker, Sanya Samtani. Sanya is from Bonavero Institute of Human Rights, Oxford, and perhaps Sanya can share her experience and knowledge on the human rights moot court context. Sanya, time is yours.
Thank you so much, Neelam. Can everyone...
Excuse me, I think I would like to remind all participants that if you are not a speaker and if you are not sharing ideas or giving comments, could you please turn off your camera and turn off your microphone so that perhaps it can help us to receive a better connection for our meeting. Thank you.
Thank you for that, Neelam. I hope you can all hear me clearly. If you can't, please type out a message in the chat and I will turn my video off, stop screen sharing.
It's very clear. It's very clear. Yes.
Thank you so much. Yeah, so thank you everyone, and thank you, Sascha, for this kind invitation. I can see that the part of my presentation where I talk about how to moot when the internet is tricky and when connectivity issues arise will be relevant to this presentation. So I'm going to go there quite quickly. As you can see, today's presentation is about how to take mooting online. And the picture that I have is a picture of a phone, because I'm going to talk a little bit about how to phones.
Oh my God. Can the co-host help me to mute the participants who is disturbing this meeting? Yes, Sanya, you can continue.
Yeah, let me proceed. Thank you. Okay, so Moving on to the first slide, you've already got quite a lot about why mooting is important from both Sascha as well as Iqbal. But I just wanted to reiterate that because law is such a powerful tool, mooting is important to build generations of young lawyers who can also apply the law rather than just studying it in the abstract. So even if students don't want to be litigators, mooting is still important for this reason. I'm talking to you specifically today about human rights mooting, but the general principles that I talk about are applicable to all forms of mooting in all subjects. Specifically, human rights mooting is important because what it does is it teaches you how to use the law for social change. And you can also learn how to construct a legal argument from the one side, and then to deconstruct it, to look at all of its weaknesses, and to see how best to bolster your own argument on the one side. It's also important because it helps with strong legal argumentation skills, both oral and written. And it also builds a wonderful community across the world. So I very recently found out that the Office of the High Commissioner for Human Rights has linked both to the Price Moot as well as the Mandela Moot on their website. And they have suggested moots as tools for human rights awareness building and building of human rights activists. So that's the sort of impact that mooting can have on young people's minds and on building future generations as well. It's also particularly important to try as much as we can to stay connected during COVID-19 and not to forget that human rights are important even now. And in fact, particularly because COVID-19 has exacerbated so many inequalities across the world, human rights are even more important at this point in time. I'm now going to move to the next slide. So this is a little graphic about the Price Moot. I'm one of the 4 mooting coordinators who organized the Price Media Law Moot Court competition, which deals specifically with issues in freedom of expression and media law, includes other human rights that are related, like freedom of religion, right to privacy, etc. And the Price Moot it's very much based on real situations that take place in the world. Our current moot problem is somewhat based on the global pandemic. The reason for this is deliberate. What it does is it helps students equip themselves to understand the world around them and then to grow into people who can change that world for the better. This little graphic is the numbers that you see are the participating teams in the international rounds only. But we've got 8 regional rounds and we've got around 350 teams that participate across all of the 8 regional rounds. The regional rounds are listed on the screen: Northeast Europe, Southeast Europe, Northern Europe, Africa, Americas, Asia Pacific, and South Asia. So what I would do is I would encourage all of you to consider participating in the Price Moot as well, because that would give you a sense of how we're running the Moot online. I can talk about that a little bit more in my next slide. This pictures of the International Rounds 2020 that we had to take online because of the pandemic. And these are screenshots of some of the speakers who sent in their oral pleadings, in their recorded oral pleadings. I will also talk a little bit more about that. So if you'd like to find out more about how your university can participate in the Price Moot, please write to pricemootoxford@law.ox.ac.uk. The email ID is on my screen. And this is just a small snapshot of how we took all of these things online, all of these moots online in this past year. So the international finals of the Price Moot were taken online in March earlier this year. And the regional rounds for this year's competition, that is 2020 to 2021, will be online all through late 2020 and early 2021. So far, we've had the Southeast European rounds that have successfully taken place online last month, and they went off well. And we're going to have the other rounds forthwith. We are also going to have the international finals online in April. And the plan for the international finals is to do it via Zoom, which I can talk about further as well. Just a small aside as well, for other human rights moots that have gone online, the Mandela Moot has done that, and they have just recently concluded their finals with 2 Kenyan teams fighting for the championship of the Mandela Moot. And that particular Moot as well has used some of the techniques that we use to put up the Price Media Law Moot online, because we consulted to help them do that. So the basic elements of a Moot are to have the rules of the competition, and we would tailor those rules specifically to the online forum that it's going to be used at. Within those rules, it's important to have a clear statement of jurisdiction and the applicable law for that particular Moot. As Sascha was saying, it's particularly important to understand how the law actually works in practice, and using existing cases is helpful in that way. The problem or the competition case is what would then capture that, which is, it would be hypothetical, but it would be based on something real. And what we encourage is the creation of a bench memorial. So it's a sort of compendium of arguments for the judges to look at when they ask questions to the teams during the competition. What we try to do as well is to release certain basic documents. So the Jessup Moot does the same thing. Basically, we put together, say, about 10 documents that are absolutely essential to understanding the case. And that gives the participating teams certain direction in terms of where to go. Written memorials are things that the teams submit with their written argumentation. And then we provide the score sheets to the judges for that. Oral pleadings as well, you're familiar with that. And then we also provide the score sheets. The organizing team will provide the score sheets to the judges for that. We also create judge and team briefing documents, just to explain what I'm explaining to you, which is how the competition will proceed, a sort of short form of the rules of the competition. And then we create matchups as well as judge assignments to match, the matchups are largely random, that is, which team is playing against which other team. And the judge assignments are something that we do keeping in mind the experience of the judges, etc. So how did we take this Moot online? Particularly because we had to do it at such a large scale, we had to come up with certain infrastructure for us to be able to effectively carry this out. So we have a core organizing team of 4 people, including me, and we've got regional partners as our point of contact for our 8 regions as well. And what we do is we have developed a system where we either use Dropbox, Google Drive, or any other cloud storage facility that is familiar with, that the regional partners are familiar with and that works in that region in order to set up this network. Alternatively, using email is perfectly fine, or WhatsApp even, if your internet doesn't work so well, or Messenger or any other sort of messaging software that messaging app that allows you to send documents and video. So what do we do? What do we create really with this? If it's cloud storage, we create folders for teams and folders for judges. If it's email, WhatsApp, or Messenger, or other chat programs, we create a chat or an email chain for teams, in which we exchange memorials online. So we ask teams to email in their memorials, and we exchange that. We also exchange the completed score sheets from the judges from the preliminary rounds and the certificates at the end of the competition. And this is quite important, the recorded oral pleadings of opposing teams. So I'll talk to you a little bit more about that in the next slide. But the point is that whatever infrastructure you create, it has to be able to support, at the very least, recorded oral pleadings. So it can either be audio recordings or video recordings, and documents. Additionally, for the judges, we've got the memorials of the competing teams. So we create match folders for the judges. For example, if we have team A playing team B, then we create a folder A versus B, and then we share it with the relevant judges of that particular match. In that folder, we put in the memorials of the teams that are competing, empty score sheets for the judges to fill out online, recorded oral pleadings of the competing teams. Again, like I said, I'll speak about that in the next slide. And the bench memorial, which is what I talked to you about in my previous slide, which is a sort of compendium of arguments so that the judges are familiar with the issues that have come up in the Moot. So let's move on to the oral pleadings particularly. The oral pleadings can be either through video conferencing software, or they could be through recordings if there are connectivity issues with the video conferencing software. So what we did for the March rounds, the March international rounds, because we had such short notice and we were concerned about various teams in different regions not being able to access video conferencing software at short notice, we asked teams to record their oral pleadings and either email us or put it in the folder that I described earlier, upload it to the folder that I described earlier. Fairly simple. Teams are only required to use cell phones, or they could use any other sort of recording software, but we haven't asked them to use anything too sophisticated or too difficult. Cell phones are fine as long as there's clear articulation of their voice, because that's the most important thing. If video is not possible for whatever reason, teams may record audio only. So for example, if it's becoming extremely difficult for teams to upload video recordings of themselves, using voice recordings or voice notes are also a possibility in the absolute worst case scenario. I will explain how we adjusted the scoring system to account for this in my next slide. Once recorded, as I mentioned, the teams are requested to either upload it online in the folder, which it just involves dragging and dropping or clicking a button, or if that's not possible, to send it to us via email or WhatsApp or any other chat program by a particular date. The only downside to this, and this is also something that Sascha pointed out in his presentation, that it's not going to be exactly the same as a real life moot, as a physical moot, because there are no rebuttal possibilities. Teams cannot respond to the other team's arguments in the rebuttal time. And it's difficult because there are no questions from judges that are possible as well. This is the only trade-off, so to speak. The next slide now talks about the other two things that we did to kind of recalibrate for the online system. So the first is that we gave the assigned judges the time frame to listen to all 4 of the pleadings. So we had 2 pleadings for applicant and 2 for respondent in any given match, 2 speakers for applicant and 2 speakers for respondent. And we assumed, given, and this is probably going to be the case, in different countries it will be different given the fact that the rules, the restrictions related to the pandemic are different in different countries, given the number of cases, etc. But we assume that team members are not going to be in the same room. So we assume the worst case scenario where different team members are in different places and cannot meet. So then we accounted for receiving individually each speaker's oral pleadings. And then we collated that and provided it to the judges. And then we also provided score sheets to the judges. So how did we recalibrate our score sheets for online mooting? So the first thing we did was we reduced emphasis on style. We made it clear, we reduced the number of points that we gave to style. Instead, we increased those points for structure and the quality of argument. And the research that went into making that argument strong. And then we also encouraged written feedback from judges to sort of say what they liked about the presentation, what they did not like, but in a kind and constructive way, and keeping in mind that a lot of different participants are going through different things in different parts of the world in the current difficult time that we're all in. So as an alternative to recorded pleadings, we could use video conferencing software. And again, that's something that we're trying for this year. So the Southeast European rounds used video conferencing software, and the Mandela Moot did that as well. So you can use anything like Zoom, like we're using now, Hangouts, which uses lower bandwidth, GoToMeeting, also lower bandwidth. And the other possibilities are listed on the screen. But of course, it depends entirely on that particular region, whether whatever's familiar with participants are familiar with, etc. So this is something that we've seen in different parts of the world where network providers, cell phone network providers, they have not sponsored it for a moot yet, but they have been interested in potentially sponsoring data. So I know that this has happened with certain conferences in various countries where it was difficult to access internet, and cell phone network providers agreed to sponsor data for that particular event. So that could be something that you think about for this for a Moot that you're planning to organize online. It would be, of course, preferable, as we have seen in this webinar as well, for participants to have video on while speaking, but sometimes that's really not possible. So audio is fine. With Zoom, it's interesting because you can also phone in if the internet isn't working. So that's something else you can consider. It's the same thing for judges, audio, if video is not possible. And like I said, we assume that all of the participants are in different places because of the pandemic. So we provide them with a little bit of extra time so they can chat to each other in different places for rebuttal. And there will be, so the good part about doing it on Zoom or video conferencing software is that participants can engage with the judges more. Judges can ask questions and participants can have rebuttal and rebuttal, my apologies. And then finally, the timelines. So if you're thinking about doing oral pleadings through video conferencing software, then it's important to think about the timeframes, particularly for us, because we have 8 regional rounds and we're looking at around 30 teams for the finals this year, that is in 2021. And these 30 teams will be drawn from these 8 regions across the world. So we are having to factor in time difference from teams across the world. So our plan for the coming up, for the finals that are coming up is to have longer timeframes, which means that we may not have more than, say, 4 rounds, in a day, or alternatively, we have to ask for some teams to adjust to kind of ensure that we get the right time, similar to this webinar. So that's particularly important. And there's also a shorter time frame for submitting and judging recorded pleadings if the pleadings are recorded, because really the judges across the world can look at it in their own time zone, and it's not going to require too much more time if we have recorded pleadings. So that brings me to the end of my presentation. I'd just like to reiterate, I'm happy to answer any questions that you have about how to move Moots online. I've provided a very practical sort of overview of what we're trying to do this year and what we've already done, and the advice that we'd given the Mandela Moot and how they've successfully also concluded their online Moot. So do ask questions when there's time for Q&A, and thank you so much. I will hand over to Neelam again.
Thank you, Sanya. Thank you. It was an excellent presentations. And Bapak Ibu sekalian, for the last speaker is from Thomas Biemeyer. Thomas Biemeyer is a director at Wildgen, Luxembourg law firm. So of course, with this, we know that Thomas is very experienced in not only moot court, but the real court experience. Please, Thomas, you can share your experience on moot court competition and court. Thank you.
Great. Thank you. Thank you for the invitation to speak at this workshop. Also, thanks to the previous speakers. I think that has been very interesting. Also, the different ways, I think, how to tackle the challenges through online mooting. I'll just quickly check that I can share my slide. Okay, I will try not to speak too long. I think 10 minutes should be top max, so that we still have a few minutes to discussion of the points also raised by the previous speakers. I will talk about lessons from the European Law Moot Court competition. Try to be complementary to what the last speakers already mentioned, because I think the European Law Moot Court competition and the prize moot to a certain extent work, of course, in the same way and have been faced with the same challenges when moving the moot court online. So I will quickly talk about what the ELMC is so that you have a little bit of an overview what this Moot Court competition is about, who participates in the ELMC, because it's not only students, why participants participate, what the online version is that I think differs a little bit from the prize Moot, and what are lessons to be learned also from the online version of the ELMC. So what's the ELMC? The ELMC, as the name says, is a Moot Court competition about European law. So it is to a certain extent rather broad, because it can be 1 year a topic on human rights, another year on company law, another year on competition law. So it depends. It's always on a topic which is at the moment important at the Court of Justice of the European Union. It was founded in 1988, and I think that's important, and I will rather focus also on this part of the Moot. Of course, the Moot Courts are about developing skills and knowledge, but I think it's also very important for community building. In 1988, so you have to see this a little bit in the perspective of the European Union, you have the fall of the Berlin Wall, you have, that's 89, you have 88 to 91, the dissolution of the Soviet Union, and you have a very strong development for the European Union as a community. And that, I think, is also something that resonates very, very strongly in the Moot Court competition. About 80 universities across Europe participate each year, not only from Europe, but often also from the US and other countries that deal a lot with European Union law. So that can also be Switzerland, Turkey. We have often a couple of Russian universities that participate. It starts every year about September. We have a case with case facts of about 3-4 pages. There's first a written round that takes about 2 months, in which the students, together with a coach, which is generally a university professor, work on the case. They have to do written memorials, which they have to submit on a deadline, like in a court case. And thereafter, basically for a month, for the students at least, there's not a lot that happens, because the judges will evaluate. And from these about 80 teams, 48 go to 4 regional finals that take place all over Europe. So it's generally always universities that organize them. They take place between January and February. 12 teams go to each regional final. They compete there in oral rounds. And afterwards, well, from each regional final, you will have a winner. And they go, and that takes place then in April, they go to Luxembourg, where the Court of Justice of the European Union is situated, and they plead this case in front of the Court of Justice of the European Union, so in front of actual judges of this court. And that's a bit, I would say, the dream, of course, of the students, to stand once in front of the court and plead their case. Huh? Now, that means you have quite a lot of different participants. So you do not only have the students that participate as such, but you have coaches from the universities that coach the teams, that they're not doing this on their own. You have judges in the regional rounds, which are generally well-established practitioners. They might be previous judges of constitutional courts, or even of the Court of Justice of the European Union, might be professors, rising stars in that field of law. Quite different, and they judge during the regional rounds. Then you have the judges at the Court of Justice. And you have, I would say, law firms participating in forms of sponsors, and you have universities participating in the form of providing the regional finance because they need to be organized. And as a last, and that's where basically I also come in, you have a overall society. So the whole competition is not student run, but it is run by a society of people like me. So people that work in practice, some work at the university. Our president works at the Court of Justice of the European Union. The vice president is the director of communications of the Court of Justice of the European Union. And they all, and I think that's the next point, why do students, litigators, law firms, and so on participate in this competition? Because students, of course, because they want to get this experience, and I think we discussed this already, they want to get the experience, they want to get the skills, they come to the regional finals and meet. I think that's a very important aspect. It's not only about the skills transfer, but it's also about people from a lot of different countries coming together at the regional final or at the final and just meeting each other. I think it's a very important part of simply community building, and community building not only for the students, but the judges that judge, they also come together. They come to the regional finals, they know each other, so once per year they come and exchange ideas, and the law firms participate because, of course, it's interesting for them to see these new, basically rising stars, the students, because that's basically also they obviously always need new juniors for the firms. And the universities also participate because it's quite prestigious. Now, of course, this had to be moved online, unfortunately, due to COVID-19. For us, the first one was the final in Luxembourg that needed to take place completely online. The regionals were still possible. Now, I will not go, because I think the last presentation already dealt very much in depth in how this can be set up. I can just say this was in the ELMC done through Zoom. I think that works in the end pretty well. I think what's important, and that's where I would like to focus a little bit more on, I think the online mooting, of course, changes the whole idea a bit of the moot court competition. Huh? Certain things definitely stay the same, I would say, and I think they also reflect very much the practice, how it actually works afterwards. So you have in the moot court competition first the written phase, where teams work together in order to establish the written memorials, and they do this together with the coach. I think this phase has not changed dramatically. It doesn't matter basically whether the students are sitting together in one room or whether they have to do Skype calls. I think that's exactly what is like in practice, because if you imagine you work on real cases, and it's not like all litigators sit together, they sit in the big cases, they sit in a lot of different jurisdictions, and they do exactly the same. They write each other emails, they have Zoom calls, and I think this reflects very well what's also happening in the real world. In the second phase, of course, then it's different, because it needs to somehow take place online. Of course, at the courts, we have at the moment also online hearings. So you could also say from that perspective, it works quite similar. But I think, and that's where the main lesson I want to draw to, where of course the challenge lies, is the whole networking aspect as such is very difficult in an online moot context, because of course there's a skills transfer and there's a knowledge transfer, but I think it's also very important that people come together and meet, discuss the case, get to know each other. And of course, that's like for any workshop, conference, people come together. It's a very important aspect. And that's simply what an online version, of course, I think, or I would like to hear your thoughts on this. I think is very difficult, that can be achieved. Question is the online mooting for this reason, let's say, much worse? I think we just have to see look at different advantages that the online mooting brings, and I think that's also what Sascha already mentions. Of course, the networking aspect and the community building aspect is less, but of course the entrance barriers are much lower. So teams, normally the teams, for example, in the ELMC, they have to fly to the regional finance, and there are costs involved. Now there's no costs basically involved anymore, because everything, well, not no costs, but the costs are very lower. So I think it also opens up again for opportunities, because teams that may not be able to participate normally can participate. So I think there's advantages and disadvantages that can be seen from the online version. There's of course the technical aspect that needs to be solved, and I found the last presentation really interesting, and there are also some lessons I think I will take back for our own mooting, how to overcome things, and we have seen this in this presentation. Sometimes then the connection is bad. There's a lot of things, of course, that can happen and that need to be regulated somehow. And I think, yeah, I can only repeat, I think the last presentation on this was very good. So I would think if you have any questions on the ELMC, I could also speak more in detail about how we exactly set it up online, but I think basically we do it very similar than the prize moot. So I thank you, and I'm happy to answer any questions.
Thank you, Thomas, for your presentation on European Law Moot Court Competition. Bapak Ibu sekalian, itu tadi presentasi dari 4 speaker. Speaker. First speaker is Pak Iqbal, second speaker is Dr. Sascha, third speaker is Sanya, and then the third one is Thomas. And they already shared their experience on moot court competition and conducting a moot court. Now, I would like to invite Bapak Ibu sekalian untuk menanyakan pertanyaan kepada all the speakers here. If you are not comfortable in speaking in English, Bapak Ibu sekalian bisa mengetiknya dalam bahasa Indonesia atau langsung raise hand. You can always raise hand, use the raise hand buttons, and I will give you the opportunity to ask directly. Yeah. Does anyone would like to ask question? If not, I personally have a lot of questions actually, but later, if after no participants raise hand, I would like to ask, because this is very interesting. And I myself is the coach for moot court IMLAM, International Maritime Law Arbitration Moot Court Competition for Universitas Airlangga team. Ya, Bapak Ibu. I haven't seen anyone asking questions.
Saya tanya langsung ya.
Oke, ya, silakan Bu Lani. Ya, please,
sorry.
Bu Lani.
Soalnya cari raise hand nggak ketemu.
Alright, okay, that's fine.
Ya, ini kan tadi tentang competition ya. Tapi sebetulnya yang saya inginkan ini adalah bagaimana untuk moot court yang sekarang di kampus. Karena untuk saja kan harus ada 3.
Ya.
Itu sebenarnya kita kan dreaming. Jadi bagaimana mengelaborasi, mensiasati yang hanya ada small group, jadi ada small group yang lain-lain itu supaya bisa lewat daring. Ini saya tanyakan.
Ya, terima kasih Bu Lani. Walaupun agak pecah-pecah nanti dikoreksi kalau ada translation saya yang salah. Well, Ibu Lani Ramli asking questions that the speakers just now, the speakers just now share experience on moot court competition. But Bulani would like to know, how do you teach a moot court in a university level? And because now in this moot court teaching, Bulani needs to put the students into smaller groups, because some of the roles in previous moot court teaching cannot be done. Yeah, Bapak Iqbal, perhaps anyone would like to answer Ibu Lani's question? Perhaps Dr. Sascha?
Yes, I was just getting ready. So I think one, of course, if I understand the question correctly, yes, there are organizational problems in doing this while teaching, especially since I know that teaching at Indonesian universities usually involves very large classes, 40, 50, 60 people. So teaching it or incorporating it in a normal course setting, it can be difficult. Still, I think it can be done. It is a useful preparation for the real moot court modules that you have, that Pa Iqbal was talking about. Even if you have a large class setting, if you take 1 hour out of the day or out of the session of 4 hours, to let a number of small teams in front of the others who are then simply audience or possibly take a different role or take turns. Let a number of students in smaller team moot against each other in the normal course setting. I think that is already quite some preparation and goes a long way in making students get used to mooting, because I know in some teaching contexts and some educational settings, it is not normal for students to speak very much. And that is something that mooting very actively helps to overcome. And it can be done even if just gradually more and more people in the normal teaching setting are encouraged to moot against each other.
I mean, in pandemic time, we cannot join together, although in small group, because the activity in campus is by daring or online. I mean that.
Ya, tetap saja bisa dilakukan. Tadi sudah dijawab oleh Dr. Sascha. Thank you, Bulani. Perhaps you can mute yourself now. Now I would like to give opportunity to other participants to ask questions. Silahkan, yang mau bertanya. You can raise hand or type your questions on the chat box.
May I?
Yes, please. Silahkan.
Okay, thank you, Bu Nilan, for giving me a chance to ask a question. Thank you. My name Ferry Kopa. Daily, I am a visiting lecturer in Universitas Muhammadiyah Sumatera Barat, Bukit Tinggi. So in this case, by digital moot court, as we know in Indonesia, for this course, we usually we have barriers to build the capacity or the legal reasoning of the students. So I would like to ask all the speaker by their experience, how can we what can we do to improve the capacity of the student in legal reasoning? It is the most of the weakness of the student in Faculty of Law in Indonesia. So I would like to this question to the from the speakers. So before that, I would like to okay.
Ferry, which speaker, please?
So yeah, I would like to ask
only one.
Only once.
Yeah, because we have I believe we have questions. We will have questions from most of participants. Okay, only one, Pak Ferry.
Yeah, I think it is from I would like to ask from Sascha how can we improve our students' capacity in legal reasoning?
Yeah, okay. Thank you, Pak Ferry. Yeah, okay. Dr. Sascha, you can directly answer Pak Ferry's questions. Pak Ferry, you can mute your microphone now.
Thank you very much for the question, Pak Ferry. Good to see you again. Well, I think the answer, both in digital moot court times and in any normal times, is to just practice much more, get students involved much more. What we do in the LEAP project, and I think in similar projects in Indonesia, it has been tried before, is change the manner in which we teach gradually to get students more involved. Because legal reasoning is a skill which you do not really acquire by learning facts or by receiving knowledge by listening to lectures. Legal reasoning is something that you must learn how to do, and that you can only do by practicing it. So therefore, working, for example, with fictitious case scenarios which students have to solve, of which mooting can, of course, be a big part. Or working with discussion-based teaching instead of frontal lecturing. So all of these methods which are student-centered and which activate student participation can help improve that skill. And I agree with you that this is something that's really necessary, a necessary part of modern legal education.
Okay, thank you, Dr. Sascha. Next question. Does anyone would like to ask questions, and preferably perhaps to the questions to Dr. Sanya or Thomas or Iqbal perhaps? Okay, Bapak Gabriel Arif, I can see you already raised hand. Please turn on your camera and unmute your microphone.
Sorry for my camera cannot be on because my camera is broken. Is it okay?
Yes,
hello?
That's fine. That's fine. That's fine.
Okay. Okay. So I want to ask to all speakers. So one of the objectives of the moot court competition is to provide an experience for participants to feel the atmosphere in the courtroom when the trial of the case is underway. So it's not just about teaching how to make legal files, how to act as a lawyer or prosecutor or judges and stuff like that. So my question is how to bring up or live up the atmosphere in the courtroom while we are using online methods like these days. Thank you.
Gabriel, and that question is for siapa?
For all.
Oh, only one, only one.
Maybe Mr. Sascha or Miss
Sanya.
Yeah.
Sanya?
Yeah.
Okay.
Yeah.
Because Dr. Sascha already answers some questions. Now I would like to give opportunity to Sanya to answer the question.
Okay.
Sanya,
That's fine.
please.
Thank you so much. That's fine. Thank you so much.
For the question, and thank you for the opportunity to answer it. It's a very good question because this speaks to what Thomas was also saying in his presentation, which is that really just physically coming together and creating that atmosphere is something that online mooting has to do a lesser version of. But it can be done. So for example, what we try to do is we get the participants and the judges to dress like they are actually going to be going to the moot court competition instead of just sitting in their houses and calling people up on Zoom. So that helps a lot. Teams take it very seriously as well. And then we also have timekeepers in the Zoom room, for example, who will, like court clerks, who will call out, who will say, the court is now in session. We would like to introduce the judge president and then the name of the judge who's going to be the presiding judge, and then the two other judges. And then we also try to keep courtroom manner throughout the moot court competition. So participants call the judges, judge, and then the name of the judge. And then the judges call the participants counsel or agent. So this is the way we try to maintain courtroom manner within the online Zoom room as well. And I think that all of that really creates that atmosphere. If Thomas has anything to add, then please go ahead. But yeah, this is my contribution.
Yeah, perhaps Thomas, you can add.
Sure, of course. I think I think it's exactly that. By just trying to create the same atmosphere, by people dressing up in the way, by having people exactly introducing the judges and everything. I think that works very well. And I think what we should also not forget, and that's just from my perspective or experience as a litigator, it is in the end, you know, the courtroom, of course, creates a special atmosphere, but don't underestimate that if you stand in front of the judges and you plead your case, I think what creates already the atmosphere is the pressure you have on you. You know, you stand in front of the judges. It doesn't matter whether you stand in front of a camera and you plead your case. At least myself, I forget that at that moment. I either stand in the courtroom or I stand in front of the camera. But the most important point is basically that I plead my case. You know, and I think from that perspective, because you want to win the case. And I think that also remains if you do it online. So I think it works online very well if you take what Sanya just said, and generally I think create just a case where everyone wants to win. Then I think the students will very easily forget that they're actually in an online setting, and it will work perfectly in the sense of an online thing, but I think it can work very well.
Yeah, thank you, Thomas. Well, yeah, the pressure is real, you know, like it's, we cannot differentiate which one is a real court and which one is moot court. The pressure is there, the same. Now, Bapak Ibu sekalian, is there anyone who would like to ask questions to the speakers here? We have 4 speakers, Thomas, Sanya, Sascha, and Iqbal. Ya, siapa yang mau bertanya? Like I previously mentioned, if you are not comfortable in asking question in English, you can always type in the chat box, and I will translate it to the speakers. Kalau tidak nyaman dengan bahasa Inggris, boleh ngetik di chat box. Saya akan mentranslatekannya ke para speaker. Ya, jika tidak ada pertanyaan, saya I would like to well, the reality in Indonesia is that in moot court, not competition, but the moot court course, the students also act as a judge, and this is quite different from, and this is also happens in moot court competition in Indonesia. in Indonesian law. But if we compare to international law moot court like Philip C. Jessup, or the arbitration moot court like IMLAM, or the ICC moot court, it's quite different because the judge is not the students and they are not the participants of the competitions, and they are real practitioners like lecturers, or the real judge, or practicing lawyers. Now, what do you think about this? I would like to ask to Sanya or Thomas, both of you, what do you suggest in moot court competition, online moot court competition in Indonesia, if we have this online competition? Which should we follow? The judge is also the students, or the judge is the practitioner, the lawyer practitioner? Sanya or Thomas, perhaps, if I can ask questions to you.
Thank
because
you.
this is very interesting. Yeah.
I can answer, and then maybe Thomas can answer as well from the perspective of a litigator. So when I was in I did my law schooling in India, and we had the same issue where the senior students to us would act as the judges, and then the junior students would be the participants. So we tried to do it. That was one way in which we did it. But whoever was the judge, we tried to first make sure that the person acting as the judge had an interest in that particular subject area, had expertise in that subject matter. So they should know the law better than the participants, for example. That was one thing we tried to keep as much as possible. And what we tried to do was we would try for the advanced rounds, like the semifinals and finals of the internal moot court competition, to definitely get practicing lawyers or lecturers or judges, if possible, to actually judge those rounds. But this was because we were obviously constrained by budgets within the law school, so we couldn't. It wasn't possible to really get people from outside for every single round. So we had to do it like this. But for example, with the Price Moot, we do have students judging the preliminary rounds, but they're students who are doctoral researchers, for example, or they are graduate students who already have, like I mentioned earlier, an interest and expertise in that particular subject matter. The Jessup also allows, the Philip C. Jessup competition that you mentioned also allows for graduate students to judge. They largely do that for the preliminary rounds as well. So that's the sort of balance that we try to strike even with this moot. Thomas?
Yes. I think it depends a little bit on what you want to achieve with having students or practitioners as judges. I think if you want to have a moot court where a certain amount of students can experience the role of a judge, and that's the objective, I think then you need students to act. But I think that's what the European or international moot courts are more about. It's not that participants can experience the role of a judge, but it's more having indeed someone with experience. And I think it differs, at least on the example of the European Law Moot Court competition, for example, the judges ask questions. So the participants plead, and they may get a legal question or a factual question, in any case, on the case. And I think if you have students as judges, which have the same level of legal knowledge, I think then it's very difficult that they actually ask these kind of questions. But if you have practitioners, then they have the general overview of the case, they have the knowledge, they can ask questions. I think, and also coming back, how to create more this real experience. I think if you have a practitioner sitting there, it also creates this more real experience. And it actually also creates the pressure, because the pressure is not only created by the grade. Let's say you grade everyone and you say like, yeah, but you have to do well. I think it's much more the case that as a pleader, it's not like I'm afraid of the questions I will get, but I have 2 or 3 practitioners sitting in front of me, and they will ask questions, and I don't know what kind of questions they will ask. And I think this creates really this experience, which you also have in the courtroom, because the judge, at least in our system, can also ask questions. you have more of this, you don't know what's going to happen. And I think if you have students sitting there, then you're like, yeah, okay, that's my fellow students. I mean, they will not ask so many difficult questions. And I think now potentially an advantage of the online system, because I think it's a logistical problem normally, because how do you get these practitioners actually to participate? You have to ask them to come to the university, to spend half of the day judging students. This is quite difficult, but in an online setting, they also just have to basically turn on Zoom, and you can, for example, ask them to judge just 2 or 3 groups, you know? So in this sense, for them, it's not a lot of time investment, you know? Maybe they spend an hour or 2, or maybe just 40 minutes or 30 minutes. But I think the entrance barrier of getting these people in a sort of online environment is much easier. So from that perspective, I think at least it can be tried that you do it with practitioners and you just contact them and say like, okay, we're having this moot court, you're an expert in this area. Would you be available to judge a couple of our students? And I think normally the feedback is very well on things like this. And I think that's also nice for the students. Even if it's online, they're creating their own network a little bit with this, you know, because they're meeting them. Maybe they can ask afterwards a couple of questions to the practitioners, not related to the moot court, but like, you know, how is it in general in your practice? You know, so I think it creates already something which is really nice for the students, but also for the practitioners, because also these practitioners often like to come back to university because they also want to study it and share it with their experience, you know? So it can be, in any case, a win-win situation for everyone.
Thank you, Thomas and Sanya, for answering my questions. But yeah, it's a little bit, no, not a little bit, but a lot of difference from what happened in Indonesia. I believe, well, it's been like 20 years since I graduated from my bachelor degree, that I haven't involved in national moot court, but I involved in Philip C. Jessup and also IMLAM as well, International Maritime Law Arbitration Moot Court. But it's very different because from what I understand in Indonesia is that the Indonesian practice, especially moot court course, is more like what you say, Thomas, that the purpose that we have is that also we need to get the students experience or get experience of becoming judges, becoming the prosecutors, and also becoming the lawyers. That's why in moot court course in Indonesia, we divided the students into 2 groups, and these groups they arrange who become the judge, who become the prosecutors, and they are separated into these groups. And also this is also happens in the competition, if I'm not mistaken, Pak Iqbal. Perhaps Pak Iqbal can also give an overview to what happened, how is the team divided into in moot court competition, the usual one in Indonesia. Pak Iqbal, perhaps we still have like 5 minutes.
Okay, thank you.
Because I mean I don't want to monopolize the meeting, because I do not see anyone here asking questions. Is that okay, everyone?
Yeah. I think what we have in national moot court competition and what we have in the course in our university is similar, quite similar. We want all the students have the experience to act a role as judges, as a prosecutor, as lawyers, as even as a defendants and a witness and expert witness. We want all of them experience that kind of situation. So when they have to work as a legal professional, they also have all the basis. Not only act as a role as a legal professional, also how to produce legal documents also. So in Airlangga, we meet students to develop their own cases, and then also the documents, legal documents, and give it to the lecturers. Lecturers will sit in the moot court room and then we'll bring score sheet, and then we'll give the score of the student, how they react for some questions. It's not like a drama. You have question, you have the answer, but in the moot court in our university, we don't have that kind of text. We don't have question, answer, and then they divide it, become question, answer, it become two teams. One team will make a question, and then the other team will make an answer. No, it's, jadi begitu saja. We have plot, but the answer and the question, it just happened in the moot courtroom. We don't make a full conversation. It's just the plot the student make from the start. So the question and answer is developing during the moot court session, I think, in Indonesia, in Airlangga especially. Yeah.
Okay, thank you, Pak Iqbal. Thank you very much for your explanations. Bapak Ibu sekalian, it's now 2 minutes to 4:30. I believe we already have a good discussions today with all the speakers here. Thank you, Thomas. Thank you, Sanya, and thank you, Sascha and Pak Iqbal, to be able to participate in this meeting as the speakers of this webinar. And to all of you, the participants, thank you for joining our meeting, and thank you for your active participations. And I'm really sorry about the connections, bad connection that we experienced at the beginning of our meeting today, because perhaps the weather is not really supportive to this meeting, and disturbing the bandwidth connections. And thank you, everyone, and I'll see you on our next webinar of LEAP-OKP. Thank you, everyone.
Thank you.
Bye.
Thank you.
Thank you, Thomas.
Thank you.
Sanya, Sascha.